Welcome back, everyone. I know everybody's still very pumped up from the earlier sessions. I just wanted to, for this last session today, I'm really excited about. Steve had said earlier about sort of, the dean dislikes you when he puts you on, after lunch. The dean just truly despises you and is trying to push you out the door when they put you on Friday afternoon during happy hour. But this is actually a really exciting panel for me. This is on value judgments through damages. And I'm really excited about the panelists today. Bert Kreitzer, who is the Marvin J. Sinoski Chair of Law and Public Policy at the University of Minnesota Law School. He has his two co-authors who didn't join us up here. Ya Liu, who is an empirical research analyst with Duke Law School, and Neil Vidmar, who is also at Duke Law School. And one of my good friends and collaborators on some earlier work, Valerie Hans, who is at Cornell Law School. And so without further ado, Bert.
See if I can turn this on. Yes, it works.
Yes, you can.
Okay. First, thank you all for staying and joining me. Sort of, think about, they put the numbers guy on at happy hour at 5 It's hard to imagine another setting where as many people would still be here. Thank you also to the staff at the Law Review for organizing this and making all of the very nice arrangements. Standard work in progress disclaimer. That's all I got to say. Steve Landsman made a comment in his talk about sort of what we know about pain and suffering, non-economic damages, which I found a little bit surprising in a sense because what's striking to me about what we know about non-economic damages, pain and suffering damages, we don't know a lot, actually, systematically about them. We have lots of great stories, examples of cases, and the like, and sort of popular wisdom, but it turns out that there is almost nothing that looks systematically at what juries actually award in terms of non-economic damages. I think this is important, or we think this is important, because there is essentially two major areas where the jury has been attacked with regards to damages. One is on punitive damages, an area thanks in large part to the work of Ted Eisenberg and his colleagues. We know a fair amount about in terms of the nature of the amounts of damages that are actually returned. And the other is non-economic damages, non-economic compensatory damages, where it turns out we actually know very little. And so what we have tried to do in this paper is pull together sources of information that might provide some insight on the nature of the non-economic damages that juries actually award. What we've done is we've modeled the analysis that we have done to date largely on the, sort of doing the same kinds of things that Eisenberg and colleagues have done comparing punitive damages to compensatory damages. We actually came up looking through various kinds of sources, a number of sources of data where people have collected information on jury verdicts and have, at least for some of the cases where they found the information, recorded separately figures for economic damages and non-economic damages. As far as we know, the only real analysis that's been done looking at these is actually a little bit of work that Valerie has done using the Bureau of Justice Statistics verdict study from 2005. What we have done is to look at now all 6 of these sets of data. The last one, the Wisconsin Bar verdict study, is something actually that I threw in at the last minute. It's not in the actual paper, but I have a little bit that I want to say about it because it turns out it has some interesting variants. There's no way that I could work my way through what all of the analyses we've done in the paper, so what I've chosen to do is to focus specifically, except for a last slide, on the Rand jury verdict study from 95 to 99. And look at the information that we have there from that set of data. What we have done is to look at the relationship between economic damages and non-economic damages in a couple of different ways. The first way is, let's back up for a moment. Okay. Escape. Just escape. How do I go back? Great. Let's find the mouse. Slideshow, play from current. Slide, where are we? From current slide. I want to give. That's what it was doing.
Oh, I'm sorry.
Previous. Okay. Now let's see if it goes forward. We're ready to go forward. Okay. So the RAND data is from 6 different states, various numbers of counties from each of those states. They cover, turns out that there are 2,100 personal injury cases with information on both the economic and non-economic damages that are awarded. It's about 43% of the plaintiff's personal injury verdicts. Important to keep in mind, that means there's 57% of the verdicts that are not included here. Some of those that may have been there was no award for either economic damages or for non-economic damages. Others, there simply wasn't a split, and we don't know which of those it is. All the dollar figures are adjusted to $1999 in this set. So we looked, first thing we did was to essentially just to plot the economic damages against the non-economic damages. We did it transforming the data to logarithms. And the major reason for doing this, if I had not transformed them to logarithms, what you would see would be one blob down in the lower lower left-hand corner of the graph, and a few scattered dots outside. You wouldn't be able to separate out anything. And what you see here, and with each of these, I also fit a line. I actually fit 2 lines. One is a standard regression line. Another is a line that allows for some nonlinearity. Generally, what you see here is the 2 lines are pretty much identical, which suggests that there is, to the degree to which there is a relationship here, it's a pretty linear one. There's a fair amount of scatter around the line, but there's a pretty clear tendency. As economic damages go up, non-economic damages go up. Not a huge surprise, but an important point to make. There's clearly a relationship. This table shows the statistical results for the different plots that I showed there. And I show the table in large part because I want to look at the column labeled R squared. That column tells you how well the straight line model fits the data. And for the kind of social science work that I do, Neil does, Valerie does, Paula does, R-squareds like this are pretty good. To be able to explain, to get R-squareds of 0.5 or better is very unusual when you've got a huge amount of data like we have here. Looks like there's one typo at the bottom that should be 0.50, not 0.05. The other thing I want to point out here, and this is one of the reasons why I want to focus on the RAND data, is that they have data from California. And California is a state where in medical malpractice cases, there's a cap on damages. And it's one of those states, I believe, where they don't tell the jury about the cap. And so it was, in theory at least, if you don't tell the juries about the cap, you would expect, there should be a lot of difference between California and the other states. But what you see here is that there's a much weaker relationship. If you look at the R-squared in the red box, you see that the R-squared in California is about half that in the other states, which is quite interesting. And it tells you one of a couple of possible things. One is that the juries actually know about the cap, and they're making awards with the cap in mind. Alternatively, it means that the lawyers are not pushing the non-economic damages because they know they're going to be capped, and maybe pushing much more heavily on the economic damages. trying to substitute economic damages, sound like a topic we heard about in the last session a little bit, maybe pushing the non-economic the economic damages rather than the non-economic damages, and the juries are substituting, in a sense, one for the other. This is just sort of a picture that shows all the regression lines on one graph, just so you can see that the steepest line is for auto cases. The clearest sort of going up most strongly is the blue line, that's auto cases. The black line is everything lumped together, and the green line is med-mal, and you notice there it's the flattest line. It's still a slope, but it has the least going up. And I tried to break out the California, the short broken line, and the non-California, the larger broken dashed line. And you can see there the difference in terms of that kind of relationship. Another way to look at the relationship is to break out the ratio of non-economic damages to economic damages, and to do that separately for different values, amounts, ranges of the economic damages. And that's what this graph does. The left shows the economic damage range, 1,000 to 90, to roughly 1 to 10, 10 to 50, 50 to 100, 100 to a million, and a million or more. And what you see is a pretty clear pattern that as the amount of economic damages go up, that ratio gets smaller and more consistent. The biggest range and the highest ratio is when you have a small amount of economic damages. And what that may mean, it may be some kind of injury that doesn't involve a lot of ultimate treatment, but it might produce a lifetime of pain. It's interesting to look at this separately by type of case. And here I've left out med-mal. We'll look at that in a moment. And again, you see a fairly consistent pattern across different types of cases, albeit for some of these, like to look at the premises liability, you get a lot, it looks like a lot more range there, but that reflects there's a relatively small number of cases. But generally, the boxes get smaller as you go up. And what the boxes represent is the middle 75%, middle 50% of the cases. Middle 50% with the line inside the box representing the median case, the middle case. What happens if you look at med-mal cases? And this is what I find in some ways particularly interesting. So what's interesting here is I've drawn the red line at 50,000 and up, and I'm not sure why the break happens there, but it clearly does. If you look at below 50,000, California and the other states, and 50,000 in economic damages, California and the other states look very, very similar. It's when you get above 50,000 that California diverges, and that the amount of non-economic damages, typically the ratio of economic to non-economic to economic, gets much smaller. And again, we don't know, is it because the juries know about the cap? It's been in place long enough in the 1990s that a lot of people would have, and the idea that there'd be somebody on the jury would say, doesn't matter what we come up with, it's not going to be more than 250,000. We're not going to deliberate for 4 days over whether it should be 500,000 or a million. It's pointless. It's a waste of our time. Or it reflects the behavior of the lawyers, probably a combination of the two. We do know, by the way, from some research on punitive damages in states that put on restrictions on punitive damages, the lawyers in those states don't argue the punitive damages as much. They argue the compensatory damages. And the same kind of phenomena may be going on when there are caps on the economic damages. This is another picture that's tracking the medical malpractice cases, just plotting them separately. And I've done the red is other states and the blue is California. And what I think is interesting about this graph, if you look below 100,000, what you see is there's a pretty even scatter of blue above and below the line. There's an even scatter of red above and below the line. You go over 100,000, the red is still pretty evenly scattered above and below the line. But the blue is much more concentrated below the line. There's some above, but there's considerably more below the line when you get above $100,000 in economic damages. So again, the same phenomenon, the impact of the cap. We don't know how the mechanisms that underlie that, but we can see the effect of the cap in that regard. So as I said, this is a work in progress. We've got a lot more work we want to do on this. One of the things we'd like to do to build into the paper some more in the way of case examples. Those of you that looked at the paper, we introduce it with a case. We'd like to get some more in it. As I said, I just started looking at this Wisconsin data literally on Wednesday. Data I've had sitting on my computer for 20 years, literally. The problem is I don't have any good documentation for the data sitting on my computer from 20 years ago. I'm trying to see if the state bar who collected the data, the director of which is once many years ago was a student of mine, whether or not they can find the documentation for the data so that we could do more with it than I will show you in just a moment. We've just, in the last 2 days, 2 days, have gotten data from the Illinois, Cook County, Illinois Jury Verdict Reporter, which we're going to be coding ourselves and adding to for the 2005 and 2010. One of the interesting things is that there is Cook County data in the 2005 Bureau of Justice Statistics data, so we'll be able to supplement what they've got for that year with some considerably more detail. But I said, this is what I want to finish with, and just in terms of data. The interesting thing about the Wisconsin data set is that they have got good data not just on non-economic damages and economic damages, but on the nature of the economic damages. They've got good data on the amount of medical damages. And you could make an argument if there's a connection between pain and suffering and damages, it probably ought to be mostly with regards to the medical damages, not to all non-economic damages, not to lost income. And so here we see the exact same broad pattern with the exception of the point of once you get about 5,000, keep in mind this is the 80s. Medical care was a little bit less in the 1980s than it is today. There were not a lot of cases involving more than $25,000 in medical bills. I mean, today you break your ankle, and I checked this out personally. You break your ankle, it's, you know, the retail, maybe not what your insurance company pays, but the retail is going to be a lot more in the U.S. than $25,000. Fortunately, I broke my ankle in England. The bill was $2,000. Full price. Full price. So if you want to break your ankle and don't have insurance, go to London. But one of the things interesting is that it doesn't drop off. It drops off gradually, but the big drop off comes early. And then it's a fairly constant ratio. So what's the import of this? The import of this is there's clearly variation in economic damages, in non-economic damages, but how the biggest variation is clearly when the smallest amount of economic damages. Very similar to what Eisenberg et al. Found with punitive damages. The pictures that I'm showing you, in fact, the paper, the first table in the paper is a table from Eisenberg et al.'s work, and it looks very much like our tables in terms of the patterns that it shows. And the same patterns generally show up regardless of which data set we look at, which kinds of cases, which states they're from, the period. It's a very, very consistent pattern. And I'll stop there.
Thank you.
Okay. So can we find you? Okay, wrong mouse. this is you. You can. Yes. Okay. Slideshow. Where does it say that? New.
Not new slide. Just hit F5 on it.
Yeah. There we
There you
go.
go.
Okay. That works. And it's that one to advance.
Which one?
This one.
Thank you. Thank you. Okay. Well, greetings. I want to build on the interesting data that Bert and his colleagues have presented for us and bring the conversation around to the political role of the jury, in particular the jury as it arrives at damage awards. And my argument's going to be that this is a very political judgment, and I'd like to talk about how it is that the jury arrives at these figures. But first, I do want to thank Megan Mitchell and the other people at the Law Review for putting on what is already a very, very stimulating conference on this amazing topic that I've been fascinated with for literally years. And I also want to thank Jason for writing an article called The Political Puzzle of the Civil Jury, because I have taken that as a jumping off point for my own paper, my own thinking in here. In a way, this paper is really a challenge to us in the jury research community to do more thinking, do more investigation, and do more research on this idea about the political role of the jury. He surveyed the literature very, very thoroughly and got lots of new things that I hadn't really seen before, so thank you for that too. But in the end, he raised doubts about whether the research that we have already collected does enough to indicate to us that the political role of the jury is operative. That is, that juries actually in the civil jury format, or whether civil juries anyway, have the ability to operate effectively as political institutions. So my response to you, I'm rising to the challenge here, is to say yes, it absolutely does. And I want to focus on deciding damages, in part because I have begun to try to think more systematically about how juries arrive at damages. It's certainly, it's very political judgment if you measure the response to jury damage awards, to be sure. But I also think a very strong argument can be made that the money awards that juries reach are very strongly influenced by community values. The worth of injuries, how much of the doctor's bill is warranted for compensation. I mean, this is some of the economic damages that Bert and colleagues were talking about, and the amount of non-economic damages that are deserved, I think, all reflect the community's evaluation of injuries, but injuries that occur in a particular context. And I think the data bear me out that injuries that occur in some particular kinds of contexts are worth more than injuries that occur in other kinds of contexts. I also think that in addition to damages reflecting community values and norms, there is a clear way in which money talks, in Steve Landsman's wonderful terminology, that the damage award served in some instances to check private power. And we've been talking about very powerful elements of society, very powerful institutions like corporations, businesses, insurance companies, but there's also the kind of homemade, humdrum kind of fence type power of one's own neighbors that are also checked, if you will, by damage awards. Those are the consequences for violating expectations among neighbors. So I'm taking my job to be a descriptive one. We've heard some wonderful, eloquent arguments on the normative side about how juries should serve political roles, and some disagreement about that. But what I'd like to do is to talk about what mechanisms I think are juries, by which juries reflect community values in their dollar damage awards. And I also want to talk a little bit in the few minutes that remain about the substance, about what the exact dollar value is and how that is influenced by community values. In the mechanisms, I'll just briefly mention a couple of models of jury decision making, and I think when you see the models that I'll describe very, very briefly, I've described them in more detail in some of my own writing as others have, I think you see that community judgments, evaluations, and assessments have lots of opportunity to influence the damage award judgment. Think about probably the most commonly discussed model of jury decision making, the so-called story model, in which jurors arrange evidence in the form of a narrative or story. The story, which follows the typical beginning, middle, end, has features the motives of the parties, usually a good guy, a bad guy, and it's coherent, has lots of opportunity to reflect, to infuse community values. First of all, what constitutes a story, and a good and compelling story reflects community judgment. The background or world knowledge, in Hastie and Pennington's terms, the world knowledge that people bring to factual representations is influenced. The schemas, the prototypes that are applied in evaluating evidence in the case, and the final phase of the story model envisions, where a narrative or story is matched up against the different verdict alternatives, also reflects community judgment. And here, just a small detour. I mean, the verdicts themselves, the amounts of damages possible, to wit, the cap, the damages that can be requested in a particular case also reflect community judgment. I mean, law is an embodiment, if you will, in community judgment. But of course, we can't write laws for all circumstances and all settings and all individual injuries. And therefore, the jury steps in, taking the broad community judgment as embodied in law and applies it in the individual case. I think, Judge Mize, this is what is meant by doing justice, right? And perhaps what even you mean, and having people arrive at a fair decision in a case, is really looking at the legal rules and trying to appropriately and fairly apply the law to the facts. Now, one of the limitations for me as a jury scholar about the story model that was a little bit frustrating is that the initial work was done with criminal cases. It's very compelling and very interesting, but I wondered about its relevance to the civil context. And even more frustrating, because I'm now very interested in dollar damage awards, it hasn't really been applied to anything. I think you could argue that the work that Sunstein, Hastie, and others did on punitive damages took insights from the story model and applied them to that distinctive type of damages. But as Bert said at the beginning, we actually don't know a whole lot about how people come up with even assessing how much of a doctor's bill should be paid, should constitute part of an appropriate damage award by a jury. Along with a colleague at Cornell, Valerie Reyna, we've tried to develop a model for this dollar damage award determination, and we think of it as taking up pretty much where the story model left off, and trying to step into the gap and try to understand this decision making. We have taken insight from a broader theory that she and Chuck Brainerd, another colleague at Cornell, have developed. They have called their model the fuzzy trace theory model, but I think it's simpler to call it the GIST model, and so that's where that's how I'm gonna describe it. It is a dual process model, and again, I'll spare you the details, which are available in some papers of ours, but in essence, people, when they are hearing information, as they might hear evidence in a court case, encode that information in two different ways. They encode it literally, that is the verbatim information that is presented, but they also get a kind of bottom line meaning of the information. So for example, if I said to you, the doctor bills were $1 million, you would encode verbatim the $1 million, but you undoubtedly would also have a kind of gist level sense of how big that number was, right? It's a kind of qualitative sense, and you might say, holy, $1 million of a doctor's bill. So that's the important, I think, insight that Raina has brought to this, and her husband, Chuck Brainerd, have brought to the study of damage awards is thinking about the different ways, of the sort of different parallel ways that jurors might encode injuries and also numbers that they hear about in a case. The thing is, gist is relative. And here, I believe, is the beauty of the jury, because it is right there in the context where a damage award is required, and it can do this exquisite adjustment of a needed number for a particular case. So this bottom line meaning, like that $1 million that I told you about, right, is definitely relative. If we were to compare, maybe I don't. Luckily, I've never had a $1 million doctor bill yet. But if you then think, oh, $1 million, the federal budget, you would say $1 million is really nothing. It is a low number. That's just one modest example of how the underlying meaning of the same verbatim information could be very different depending on the context. What some of her other work has shown is that the kind of verbatim thinking, the kind of the numbers themselves, and literal thinking is not kind of more advanced. It's not like really numerate people function in numbers. In fact, they tend to have rely more on a sort of just bottom line meaning, get an immediate sense from a number than children do or non-experts in a field. This is our model here, and we start with envisioning people evaluating case facts and the character of the parties much, and in the context, much as the story model would, and then we believe that people make, jurors make a categorical determination that damages are warranted or not, and then an ordinal determination, and this is where it goes beyond where the story model was, an ordinal determination, how big are the damages that are deserved? Are they really high or really low? If neither, somewhere in the middle. Then after an ordinal determination, and again, this is a gist kind of bottom line feeling like a really bad event, a really severe injury, damage award, though a damage award should be big, there is the selection of numbers that accord with that bottom line sense. We presume that let's say a bottom line high serious injury, high damage award would then be matched with what in the juror's mind is a large number. Where do they get the numbers? I think Burt and colleagues' data show us that they engage very understandably by anchoring in part on numbers in the case, and economic damages being a major one. And we have certainly found this in some of our other work. We also believe that jurors rely on symbolic numbers from everyday life that already have meaning to them as low numbers or as high numbers. $1 million, I think, being a good example of a large number, $1 as a low number. It's also the case, we think, that the story itself, the story that is developed by the attorneys in the case, might imply a number, and that number may have special resonance, special significance for jurors in a case. I'll give a quick example because Sheldon Whitehouse had that very powerful discussion of the Exxon Valdez accident that resulted in a large punitive damages award on the part of the jury that was then later overturned. The Exxon jury arrived at or selected, after much discussion, according to books written about the Exxon Valdez's jury deliberations, a 1 year of ordinary profits. You can, in the narrative accounts of how they got to that particular figure, one of the interesting things is they discussed and debated a lot of other numbers. They wanted a big number. I mean, they definitely wanted a big number. It had been a major and very severe accident with lots of impact, and they had some other numbers they could have picked, but for them, they identified something that was very meaningful in the context of the case. Comparably, the McDonald's very widely known coffee verdict represented 2 days of coffee sales. Again, another sort of large number for a punitive damages award that represented something meaningful. So my view is of sort of bringing us back to the political role of the jury is that for either of these models, whether the story model or the gist model, which I think of as an elaboration, you can see the importance of meaning and in terms of community understandings of meaning and also of context. I think context is very significant, very important, and that is why a fact finder deciding an individual case within a particular context, like the jury, is really ideal. What about judges? Should judges do this? I don't, Jason, you bring this question up also in your work, and here I think I kind of agree with you. I don't think we actually know enough about juries and judges and how their damage awards might differ. There is some little bit of evidence that suggests that juries might have, on average, higher damage awards, but I just don't think we can rely on that yet because there's a lot of case selection. Certain kinds of cases are sent to juries as opposed to judges, so I don't really think we can take those kinds of differences that we do see when we compare judge awards and jury awards as evidence that the decision maker is really making the difference. Judge awards do follow the same kind of patterns that Bert and colleagues showed us earlier. That is, there's strong anchoring on the economic damages for non-economic damage awards. Higher severity cases, as measured a number of different ways, result in higher damage awards. My colleague Jeff Roklinski has also shown some of the same cognitive biases with numbers and other heuristics influence judges, including, I think, the all-important experience of anchoring. The question that I think really isn't quite satisfactorily answered yet is whether or not judges' damage awards do reflect community values, or perhaps an elite slice. Are they more, as was, I think, suggested earlier, are they more subject to capture by special interests, especially because some of them are popularly elected? So I think I was so happy to get your article because it challenged me to really think about the political role of juries and how I might try to meet that particular challenge. I'm trying to describe it, and I think I'm on my way, but it's definitely a work in progress. So I asked for any insights that you all might have. I think juries are likely to have a good underlying sense about the significance and meaning of damages that drive their choice of damage awards. And you might say that through these damage awards, civil juries police the boundaries of wealth redistribution. And what could be more political than that? Thank you.
All right, Neil is just waiting here, so
Well,
Neil.
It's funny because, Valerie's my co-author on a lot of things. We go back many decades, actually. But it's funny, as you were talking about the gist, and you're talking about things, how do you get the gist of pain and suffering? Okay, that's one, but that's only one element of non-economic damages. You have loss of society, loss of consortium, loss of a normal life. And, I was just thinking a grant proposal as she's talking through this. But in fact, how do you get the gist of that? And I don't know what the answer to this is, but I think that may be a different dynamic. That I'd love to see how jurors think about someone saying, I'm no longer going to have a sex life, and my husband's not going to have a sex life, and what the implication. I'd love to hear how jurors think about that. And it's just something that I think we might even collaborate on.
Yeah, thanks for your comment. I couldn't agree more. Yeah, no, that's great. That's very interesting.
Ilya?
I wonder if Professor Hines, you could say something more about them that they have a valid and meaningful sense of sort of the correct way of doing the damages. And maybe they do, but I guess I wonder if we could try on the evidence support that, particularly given that our judgment, your judgment or mine about whether it's valid or not is itself in some ways a political judgment of. So to me, when you said the 2 days of coffee profit to
Yeah.
McDonald's,
Yeah.
that doesn't.
Were you
strike me.
horrified?
Because I'd heard it before, I wasn't horrified, but
Uh-huh.
I do think it's wrong and unjust. It implies that there should be a much different damage award if McDonald's has the exact same coffee as,
Uh-huh.
Ilya Soman's coffee shop or whatever, because I probably wouldn't sell as much coffee per day as McDonald's. And that strikes me as at the very least troubling. It may not strike others as troubling, I totally understand it, but I guess I just want to see what your sense of what is the evidence supports the judgment that it's valid, and isn't that itself a kind of political or moral judgment that of course is valid?
Wow. Well, there's actually a lot in that. And I would just say that I have done research on juries in cases involving corporations, businesses, and corporations. And it does seem to matter who engages in the wrongdoing. In the allocation of a dollar award, people do seem to fuse, if you will, a lot of different elements of the case in this contextualized way that I was describing. So they take into account whether it's a large corporation. And not, at least this is what my research and that of others seems to suggest, not because of deep pockets, which suggests, oh, well, the money's there, let's go ahead and take it. It appears to be more linked to their judgment about the appropriate standard of behavior for an entity that has a wide scope of activity, like a multinational corporation. So a kind of interesting, I mean, there is a sort of message, like the kind of message that Steve Landsman was telling us, was talking to us about earlier, about juries speaking loudly, and apparently speaking loudly, more loudly to larger entities that might, potentially harm more individuals with their actions. But, I do agree with you that there is a political debate about the appropriateness of the choices that juries make. So thanks for your comments.
One other thing I think to think a little bit about is if you're dealing with penalties, punishment, which is a little different than the straight compensation side of it. And if the punishment is in terms of a financial penalty, there is a question as to whether or not you key the financial penalty to the wealth of of who's being penalized. And there have been some systems where, in just criminal fines, where Finland, England has tried it as well, where the fines are set in terms of units, and the units are keyed to income or wealth or whatever. And if the idea is to feel pain, there is an argument that the amount of money, the wealth, is a relevant consideration in the amount you set. You may or may not agree with that, but that's one issue that could be talked about in terms of setting punishment level penalties.
Another question here.
I have two questions, and so answer either or none. The first is your having studied what you presented, but having studied these for a long time. What's your sense of the variance in jury verdicts for similar cases, and whether there is and whether it's troubling? And then the second question is sort of built on a question that was presented to Senator Whitehouse earlier. If the world were your oyster, and you could construct any study to learn more about what juries do and whether we should have more elected in the cases, what would you do?
Well, let me answer the first one, and you answer the second one. How's that? I think one of the challenges here, really, particularly if you're talking about either economic damages or non-economic damages, what's comparable? I mean, one of the challenges with, say, medical damages is, what does medical care really cost today? I mean, you've got retail, you've got wholesale, you've got Medicare, you've got Medicaid. What the providers charge, what does it mean? So, what is the cost really? And that's one of the challenges, I think, if we were to take most recent data and link it non-economic to economic, if it's medical damages, that's become such a mush. In some ways, the earlier data is probably better before these distinctions came up. I think the other issue is to what degree can you talk about similar cases with regards to even pain and suffering? That is, even on the same injury. So I broke my ankle in London. Actually, other than a little rehab discomfort, I had once they gave me once they did the surgery the morning after I broke it, I had virtually no pain. It was a nuisance, it was a pain in the neck, there was a lot of inconvenience, but physical pain and suffering I had very little. Somebody else could have that exact same injury and experience much, much more pain. I've talked to people that have broken their ankles and they say, oh God, it was really awful. And I didn't have that experience. So question is, how much do you take that into account? And I don't know what the answer to that is. In England, by the way, it's essentially scheduled, not formally, but effectively. And in fact, I figured out more or less what I was going to get in the claim I filed by looking it up in the book.
Yeah, so should we have schedules like that, or should we leave it up to every particular jury? I mean, that's really one of the implications of the questions that you asked, which I think is a really excellent question. I think when you look at scheduling efforts, there are so many difficulties and problems with them about set amounts and whether or not they can be adjusted, or maybe too much adjustment. Are they going up too fast? Are they not going up at all? And so that's one of the things I think I'm really kind of struggling with, really troubled by. But looking more at what jurors are doing as they're trying to figure out the worth of an injury also makes me despair that a scheduling approach would actually work. That I do think the evaluation of an injury is likely to be very context specific. And that means that one broken ankle and another broken ankle aren't equivalent. So I guess in that way, I'd really agree a lot with Bert, and thank you for using your own personal ankle as an example here of ways in which.
Scars?
No, I don't want to see the scars. Like on the study, I'm very partial to the old judge-jury agreement studies, and maybe you have heard about the judge-jury agreement, the famous Calvin and Zeisel judge-jury agreement study many years ago, starting in the 1950s. It's been replicated a number of times by Paula, me, and many others in this room. But the original research included civil juries, but those data were never fully analyzed. And I think it's a missed opportunity. I'd love to see a comparable study like that mounted today. At the very beginning of the jury conference, I asked the senator whether or not he had heard about this Bureau of Justice Statistics deciding to focus really on criminal cases as opposed to civil cases. I think that's a lost opportunity too. What it means is that our latest national picture of the operation of civil justice is like 2005. And my guess is, so many changes, including the financial crisis and other things that put pressure on the civil jury, have undoubtedly modified, what the civil jury looks like in practice today. And we don't have a systematic picture of it. And so I really favor some of these national projects. How about you, Bert?
Well, I would, in a certain sense, kind of second what Valerie just said. It would be really, if one could do something along the lines of what the BJS has done, knowing enough in advance and select some of the sites where you could get the judge's assessment of the damages before, and liability before the jury came back, and then later collect the jury, go back in and collect the jury data, would be sort of a combined kind of project. It would be very, very interesting to do that. But between what's happened to BJS and what probably on the 1st of March or whatever is going to happen to the National Science Foundation, I'm not holding my breath.
There's one more question, so.
Me?
Was it?
Yeah.
Okay.
What I wanted to say is just, it's funny how you sit here and think about something. I published an article in the Iowa Law Review, I don't remember how many years ago, with one of my colleagues, where they actually involved in a medical malpractice case. And I was able to get the original case, the 3 original arbitrators of this, who were judges, and put them together. And then I got a sample of jurors from 3 different jurisdictions in North Carolina and compared them to what the judges did. There was a lot of variability in the, not among the judges, but at least among the jurors, that was related to income and other demographic variables among the jurors. But in the end, I didn't have them deliberate, but I made a statistical jury out of it. They ended up with the same mean award as did the panel of 3 arbitrators. So it just sort of stimulated to me that something may come out, because there is this mix of the different views that come together, and I think that needs to be taken into consideration when we talk about the deliberation of the jury.
All right. Well, I think this is the end for today, and we'll see everyone back here tomorrow morning at 9 o'clock. Thank you all. 9 o'clock.